Good morning, everyone. Come on in. Come on in. I hope you guys had an amazing Thanksgiving with lots of food. I had lots of food. I had family over. That was fun. Good morning, Ashley. Good morning, Latoya from North Carolina. Carrie Ann, good morning. Good morning, Jola. Buki, good morning. If this is your first time tuning in, definitely comment. Let me know where you're tuning in from. This person says this holiday glow is given. Listen, the holiday has not even started. Like, I am looking forward to some time off. When I tell you guys I'm exhausted, you have no idea. I'm so exhausted. And I hosted about 15 people at our home this Thanksgiving. It was so busy. Just running it out, cleaning and all that stuff. It was an amazing time, but it was so busy. Um, Anyway, if this is your first time tuning in, welcome. My name is Aisha Chidole. I'm an immigration lawyer. I present clients all over the U.S. with their immigration matters as it relates to family-based petition, marriage-based, fiancé, naturalization, humanitarian, VAWA cases, T visas, U visas, some removal cases. We represent immigrants with all those things. Today, I want to talk about death of a spouse when they're the petitioner, the abuser, or co-petitioner. And I'm just kind of going to break them into categories. And I should have put that in the title that I'm specifically talking about spouses. So, these will include the following categories. If you have a spouse that's petitioning for you for a marriage-based case, or if you have a co-petitioner, meaning that you're filing for removal of conditions on your 2-year green card, and your spouse is supposed to be joining you, and the last one is if you are married to an abuser and your abuser passes away. Before I get into that real quick, let me answer this person. Africana Sege says, why aren't we seeing a lot of VAWA approvals lately? I filed from 2021. It's frustrating. I'm sorry that you're frustrated. We're definitely seeing a lot of VAWA approvals. So I don't know of any. I don't know. In our practice, we're definitely seeing approvals. If you filed in 2021, you're still within a normal timeline. It can take 24 to 30 months. So you're still very much within the timeline, but VAWA approvals are definitely forthcoming, and we're getting them almost on a daily basis here. Okay, so let's start with, if you filed a petition with your spouse, and during the process, your spouse passes away, you have two options, okay? So if your spouse passes away, you can, as long as your name is listed on the death certificate as that spouse, you can ask USCIS to amend the application, that's the I-130, and substitute it for an I-360 based on death of your spouse. If you do this within, and you have to do this within a 2-year timeline, if you do this while your case is pending already, then you don't have to pay a filing fee. If you never submitted a petition and your U.S. citizen spouse passes away, you can then just go straight ahead to doing an I-360 based on death of your spouse, and at that time you would be paying the filing fee. With a removal of condition, if your spouse passes away before it's time to file for removal of condition, once your spouse passes away, even if you've not hit the 2-year requirement, at that time you can file petition to remove conditions on your green card based on death of your U.S. citizen spouse. Again, a lot of these, so with the marriage one, you have a 2-year window to do that, okay? And then if you are with an abuser who, you're filing a self-petition on your own, you definitely want to, and you submitted your application, you really have two options. You can either file based on being a widower or widow, or you could file and still submit your application. It doesn't affect your VAL application if during the process of during the process of your VAL application, your abuser dies. So it still doesn't affect your application. So those are some of the things to note in a marriage-based case. It's a little bit more complex. I see someone asking me about if my parent is. What about if it's a death of a parent? Am I ineligible? It depends. A lot of times they will revoke your application if they have already approved it, and then you have to either substitute. There's a lot that goes into it, and it also depends on where you live, whether you're in the United States, whether you're out of state. So I'm not out of state, out of the US. So a lot of times it can basically become that you're not eligible, but it's one of those that I need like a specific scenario, just because it's there are just so many things to look at when it's not your spouse. Whereas if it's your spouse, they make it much more straightforward for you. Okay. And, with the spouse and with the VAL petitioner, in both of those cases, you'll be exempt from requiring an affidavit of financial support, based on the death of your spouse. All right. Let me answer some questions today. Someone says, I got an I-360 application. How long to get my green card? The answer just depends on how smoothly your case moves. If you don't have any issues with your case, then you're looking at anywhere from 2.5 years, 2 years to 2.5 years for your VAWA approval. And after your VAWA approval, usually you get scheduled for an interview bypass, and that can take anywhere from 2 to 6 months. So take as you will the timeline, but a realistic expectation is from start to finish to the date you receive your green card. For most people, I'd say expect it to be about 3 years. But, as you guys know, these are all different officers. Nobody operates on the exact same schedule and timeline. So there's no definitive for anyone. This is just an estimate. And also, you also have to think about if there are issues with an application, because those things change your timeline. If you have a notice of intent to deny, or if you have a request for additional evidence, those things kind of like delay your case in a way that if you don't have any of those things, your case might move forward. If someone gets married, how long does it take for them to get a travel document if they want to visit back home if their parents are sick? Well, Nick Sparta, the first thing is you have to actually file an application based on being eligible, based on who you're married to. So if you're married to a U.S. citizen and you're in the United States right now, you can do your adjustment of status at the same time. You can't do it right now as someone who's married to a green card holder. So if you're married to a U.S. citizen, you can do it right now. Once you submit your application, give or take 4 to 9 months, you should get your advance parole. If you have an emergency, you can present evidence of that emergency to USCIS by requesting an info pass, where you would go into the office and basically document that emergency. So in your case, if it's your parents, if they're elderly, there's a risk of them, passing away. They will then give you an emergency parole. The emergency paroles are typically going to be shorter than your advance parole. So that's another option, so that you can get home and see your family quickly. I just mentioned LPR, which is legal permanent residents, green card holders, earlier. Again, this is to remind you why. If you do qualify for something, you do not want to waste time. Time is not on your side when it comes to immigration, because immigration rule changes. So, this all changed in August, where before being married to a green card holder and you being in status, or you being a VAWA petitioner to a green card holder, you could file all of your stuff together. Now, the visa bulletin has changed, and a lot of people are looking at, like a 5-year wait. So it's really important that when you qualify for something, you don't dilly-dally. Find the resources, find whatever you need to get your applications in. And while we're at it, we have 3 more days, today, tomorrow, and Thursday, to take advantage of our $99, and then we offer 20% off of our legal fees if you already had a consultation or about to have a consultation in those days and you actually qualify for one of the services that it covers. So this is a good time to do it for our Black Friday. Good morning, Mahesh from Wisconsin. Yetunde from Houston, Texas. Good morning. Jody Bless, good morning from Florida. Jeffrey says, I sent you a PM and invite to WhatsApp. I'm not on WhatsApp, so that's our office phone. So it's most likely not me you sent it to. If you want to schedule a consultation, call the office. It's 407-995-6567. It's scrolling through the ticker on Instagram and YouTube. If you want to, and then if you want to contact me on Instagram, on Facebook, it's scrolling through the ticker. And if you want to contact me on Instagram, it should be right there in my profile. Once this live is over, you can just get the number from there, okay? Okay, let's see what other questions we have. You guys are very quiet today. Can you apply for citizenship before your extension from USCIS is expired? For those who don't know what she's talking about if you have an I-751 application pending based on you asking USCIS to remove the 2-year conditions in your green card to give you a 10-year. You can apply for citizenship if you're eligible. So, there are obviously 2 grounds for eligibility. Eligibility can be because, you and your spouse have been married for 3 years. You're still married. Your spouse has been a U.S. citizen for 3 years, and you've been a green card holder for 3 years. In that case, yes, you can apply for citizenship. The other option is if you don't fall in that category, you have to wait the 5-year. And of course, outside of you being eligible to apply from a timeline, you still want to look at certain things. So for citizenship, things that you want to look at when you're applying for citizenship is that, first of all, you want to look at your travel history, half of the time of the timeline required. So if, you're meant to be here, if you're meant to have been a green card holder for 5 years before you apply for citizenship, half of that time you have to have been in the United States. You want to look at your taxes. Have you filed your taxes? Are you paying a payment plan on your taxes? USCIS does not like to see people not paying their taxes. So you don't want to put in an application and then that's when you do a payment plan. You want to make sure you set that up before that. I've seen that happen with a client where we're like, listen, you got to take care of this. It's going to be a problem. Client's like, oh, it's not going to be a problem or whatever it is. And they hadn't done any of the payment plan. They just started paying the payment plan once we put in the application. And of course, USCIS said, this is not a good moral character issue. This is not a good moral character because you're only doing it because you're applying for citizenship, but you left it for like 2 years, 3 years, and you didn't do it. The other thing is both for women and men, not only men, for women as well. You need to make sure that if you're not in custody of your child, that you have a means to prove that you're providing for that child or those children. So if you have children that are under 18, USCIS fully expects documentation or proof that you support your children financially, whether you are a woman or a man. Again, I'm stating things that we've seen happen, and this is what the rule is, because a lot of times, people assume that, okay, it's just the guys that have to worry about child support. But for women too, you have to worry about how you're taking care of your child. If your child is not living with you, who and how do you support the child? We've been in an interview where USCIS called the mother of a child, the mother of the baby mama of our petitioner, to verify that. So he had different children, and one was already on child support. The other one that wasn't on child support, and she had written an affidavit basically saying that he gives her money and she's satisfied with what he gives her. But to verify that she was a real person and this was true, USCIS called her right then and there to verify that this was in fact something that was happening. Also, you want to make sure that during the requisite period, 5-year timeline, that you have good moral character, that you don't have any crimes of moral turpitude. If you're wondering what are crimes of moral turpitude, think about aggravated felony, think about drug charges, and things that arise to those levels. Those can also bar you. Also, sometimes USCIS, if whatever you escape from conditional green card or from B1, B2, by the time you get to US citizenship, every single thing about your life is going to be on display. I can't tell you how many times people have been shocked about what USCIS all of a sudden uncovers. They're like, well, did nobody ever ask me that? Like during the green card application, or they bypass a green card application. But citizenship, because citizenship is such a prize, so it's a simpler form to fill out, but it's the most difficult to obtain, because at that point there's very few stuff you can hide, so you want to make sure that you've done it all that. And then of course there's the test portion where you've got to do a written test and a spoken test. That's not really hard. If you understand just a little bit of English, you should be fine with that. It's literally just a sentence. Are you the president? Who's the president? Whatever it is. And then of course there's the civics questions, which I actually think that they're fun, which is basically American history. They ask you, or you expected to study 100 questions. They're not going to ask you 100 questions. They're going to ask you about 10. You just need to get 6 correct. So those are some things that you need to make sure that you're solid on before you put in a citizenship application. Okay. If you're denied your work permit, what should you do? Would need a consultation. I would need to know, why did they deny you for your work permit? What kind of work permit? What class of work permit? So I would need all that to be able to offer legal advice in a consultation. Samantha says, does a discount go as well for congressional requests? No, it doesn't. Just immigration legal services. What if the petitioner citizen? What if it's the petitioner citizen who owes on child support? If it's the petitioner citizen who owes on child support, remember that has nothing to do with a citizenship application. So they're not checking child support during a green card application. Child support is checked during citizenship. That is a time that everything is checked from a good moral character standpoint. Okay. I'm going to take 1 or 2 more questions, and then I got to jump off. Rallo, she says the applicant's name has to be on the death certificate, on the debt to be eligible to convert to VAWA. When you say convert to VAWA, what do you mean? So I just want to make sure that I'm very, very clear and that you guys are not misunderstanding, because I mentioned the I-360 form. The I-360 form can be used for several different types of application. So the I-360 form can be used for VAWA. It can also be used as a widower application, which is not a VAWA application. So I want to make sure that you understand the difference. If you are claiming to be the spouse of somebody, yes, your name needs to be on that person's death certificate as the spouse of that person. Because if they're saying that the person died unmarried or single or divorced, you're going to have a hard time proving that that's your spouse. So that's why it should be on there. Okay. Is it a good sign to get a renewal prima facie determination letter? It doesn't mean anything. And that's just the honest truth. When I say it doesn't mean anything, as long as you've gotten your first prima facie determination letter, you automatically stay in prima facie status until they make a decision on your case. I know sometimes people panic and they're like, oh my gosh, I didn't get my renewal. What does it mean? Do they renege it? No, it doesn't work that way. If you have a prima facie determination letter, you have a prima facie determination letter. So there's no such thing as them not renewing it. Meaning what it is they either didn't forgot to send it, They mailed it to the wrong address. They mailed it and it didn't get to you because this happens. But a simple request, well, it's been a long time, send it to me. They will send it to you. But it doesn't mean anything because automatically it will be renewed. As long as they are, you don't have to apply for it again. It's an automatic. As the good one is your first prima facie. Once you get your first prima facie, it is a wonderful sign. While it's not a guarantee that you'll be approved for, VAWA, it's a very good sign that you've met the core requirements. And now we're going to look through it with a fine-tooth comb at your application to make sure there's nothing else that we need from you for us to make a decision on your case. So after you get the first one, don't sweat it. Don't stress yourself out whether or not the renewal was in the mail or not in the mail, because you're still in prima facie status. Okay. All right, guys. I have to jump off, but I hope you guys have a great day, and I will talk to you guys later. Bye.